The first case to come before the court is State of Ohio v. Donna, Drockton, Carlson. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Should you want to do that, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Please don't use the names of children, minors, or victims, should that be relevant. I don't think in this case necessarily it is. But you can refer to those folks with initials or general terms. I and the other judges here have read your briefs, and we're ready to proceed when you are. And I would just ask the appellant at this time, would you like to reserve time for rebuttal?
Yes, Your Honor, I will. 5 minutes.
5 minutes. Very well. Then you may start when you are ready.
Thank you very much.
And please introduce yourself.
Yes. If it may please the court, I'm John Oberholzer of the law firm of Oberholzer and Molnar. I'm here representing the appellant, Drockton Carlson, in a matter brought by the village of Seville against her for violating a zoning resolution, a zoning ordinance of the village of Seville. The facts in this are not necessarily remarkable. Donna Drockton was raising 6 Peking ducks. She got a letter from the village of Seville that indicated that according to the solicitor, and this is where the argument begins to unfold, she had a poultry on her property, and according to the ordinance of the village, poultry violated the zoning resolution. The matter then resulted in a complaint being filed with the city of Wadsworth. The defendant appeared, entered a plea of not guilty, filed a motion contesting the ordinance as being too vague, and the matter went to trial after the court overruled the motion challenging the ordinance. And at the end of the trial, then the court made an interesting order. He found that there was no fine, costs due in 30 days, and the ducks shall be removed from the property within 30 days. Now, that part of the order leads to a situation that I would argue to the court I probably should have handled differently. But I would argue, first of all, that that language makes this a non-appealable order, not a final appealable order, because reading of the statute, I believe the complaint refers to it as Village Ordinance 1309. The only punishment that a judge can give in this matter is a fine. He does not have the authority to order the ducks to be removed. If this is a final appealable order, then we would ask the court to consider perhaps this is plain error, although the judge can issue a no fine. He does not have the authority to order the ducks to be removed from the property. And if the court chooses not to accept any of those two options, we would argue to the court that we should be given the right to file a delayed assignment of error, indicating that the judge clearly exceeded his authority. As to the merits of the case, I think it's pretty simple. Our argument is that if you're going to be prosecuted for having ducks on your property, the ordinance should say you're being prosecuted for having ducks on your property. And this is kind of a two-step process. First of all, you have to have poultry, and then you have to have a domesticated bird, and then you have to have a duck. And we're arguing that under all definitions of constitutionality, you should just say ducks. I think if there are, I believe, 10 domesticated birds that would qualify under the ordinance, and I don't know why the ordinance can't name those 10 birds. It did not, and we feel the ordinance is flawed in that respect. But most importantly is we've raised, and I'm remiss for having not raised this before today, but quite honestly, until I was reviewing this matter for the argument today, I didn't realize that the judge, by issuing a 30-day removal order, exceeded the court's authority. So I would like to call that to the court's attention and be given the opportunity to pursue that in some fashion if the court feels it's necessary.
Counsel, have the ducks been removed?
No, they have not. The outside the record,
Well, we don't need to go outside the record. I just had a question.
the answer is no. And I would indicate pending this appeal.
Okay.
Thank you very much.
Very well.
And
Well,
I
then-
reserve some rebuttal.
Okay, you will have your full 5 minutes on rebuttal.
Thank you.
Good morning, Your Honors. May it please the court, Chris Himmel here on behalf of the Village of Seville. The ordinance is not vague as the appellant wants this court to believe. In fact, the trial court on its decision in denying the motion to dismiss indicated that the Oxford Dictionary indicated that poultry as is defined includes the word duck. As was presented to the trial court, the Ohio Uniform Safety Code indicates the same definition of domesticated fowl such as chicken, turkey, duck, and it also refers to the federal regulations under CFR 381.1.
Counsel, I was just going to say, unfortunately, I am not able to pull up my briefs. This is our first time in this courtroom, as you know, and I can't just pull it up to glance at it and see what's going on here with the ordinance. But I remember when I was reading it, and, you know, it does say poultry, but then everything refers to a chicken.
The exceptions refer to the chickens and roosters, indicating that the village will allow chickens, roosters, hens in some other fashion if those conditions are met. There is no indication that a duck would be allowed under that definition.
If
So
you
what-
read that literally, wouldn't that mean you couldn't have chicken in your refrigerator without a permit? It doesn't say live fowl, it
No,
says
it-
poultry.
Poultry raised on the property. There's nothing that indicates that a dead chicken in the refrigerator that ordinance applies to, because that ordinance deals with the raising of livestock and poultry.
And you spoke of or a couple of definitions, and those definitions, but the definition that was included in the letter came after the complaint, right?
It did not, no.
Okay.
The letter came before the complaint was filed. The letter was received by the appellant, and then the appellant, as is outlined in the briefs, appeared at a zoning meeting on July 26th of 2021, asking the zoning board to amend the zoning ordinance and to allow her to have the ducks on.
Okay,
her
counsel, but when I say complaint, let me be a little bit more clear.
Sure.
Complaint from the neighbor. There's a complaint from the neighbor, the zoning, the former zoning inspector now sends the letter with the definition,
Correct.
correct? Is that the order of
That is
that
correct,
thing?
yes.
Okay, and so in the ordinance, that comes under the nuisances, unsafe and substandard buildings or structures, part of the zoning code, correct?
Correct.
Okay, and it speaks to hens, it speaks to roosters, it speaks to the kind of coops that may exist and where they need to be. And there's an exception for 6 chickens, right?
That's correct.
But why not 5 ducks?
Because the Village of Seville and the zoning board and council deemed that ducks were not appropriate to be raised as livestock within the village.
When did they do that?
I do not have the legislative history of the ordinance, but that ordinance has been in effect for some time.
Okay, and there are other definitions, right, of poultry. There are definitions of poultry that suggest poultry is, are domesticated birds kept for eggs or meat,
I would agree.
right? And were these ducks kept for eggs or meat?
It is my understanding, no.
Okay, thank you. I didn't mean to interrupt your
Yep,
flow.
You were fine, Your Honor. And I would just indicate then, going back to that, the appellant appeared at the zoning board, asked for that modification and amendment to the zoning ordinance. It was denied. She was fully aware at that point that poultry, as defined by the zoning code, meant her ducks as well, too. The complaint was then not filed with the Wadsworth Municipal Court until 17 days after that meeting. So for anyone not to understand that poultry also meant duck, I think is misleading in the argument, in the fact that there was a public hearing held on whether or not an amendment did this poultry actually mean that. And in fact, I would point the court to the appellant's brief at page 9, where they specifically state that poultry means many things. Yet they're trying to argue to this court that poultry only means chicken. If there are no more questions,
I do have a question. Many times when local government bodies are coming up with a language for these types of ordinances, they copy another jurisdiction. Do you know if there's other jurisdictions with the same
I am
language?
unaware of that, Your Honor. Thank you.
Thank you, counsel. Attorney Oberholzer, you'll have full 5 minutes.
And I would only indicate to the court that I think the argument has been made, and as it turns out, I don't know that I feel I have anything to add. So I want to thank you all very much.
Thank you both for your arguments. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you again for your presentations, and have a good day.
Thank you.